Hello everyone, I'm Cameron Diehl, the Executive Director of the Utah League of Cities and Towns, and I'm joined by Lisa Soronen, who is the Executive Director of the State and Local Legal Center. The SLLC is really the voice for local governments before the Supreme Court, and so Lisa, thank you for joining us at the League's mid-year conference down here in St. George, which is overlapping with the Utah Association of Counties. So let's start from the very beginning. What is the SLLC and what do you do on behalf of local governments? How are you our voice before the Supreme Court?
So the State and Local Legal Center files amicus curiae, or in English, friend of the court briefs before the Supreme Court, and cases affecting state and local government. So those briefs essentially say to the Supreme Court, this is how a particular issue or a particular case will affect all local governments or all state governments in the United States. So the SLLC has existed since 1983. We filed over 350 amicus briefs to the Supreme Court, and this term we filed 13. Which, if you think about it, is a lot. The Supreme Court's going to maybe decide 65 or 70 cases this term, and we're speaking to them about what matters to local government in over 10 of those cases.
That's fantastic. So you've been at the SLLC for 6 years.
I have.
Would you consider this year to be the high water mark of those 6 years so far, and if so, why? What are the issues that have led to these 13 amicus briefs that you filed?
So this term is absolutely the high water mark of my career. In fact, I'm worried it's never going to go higher than this, but that's okay. So from the perspective of the State and Local Legal Center, and the perspective of local governments, really, there's one really, really important case. And that case is South Dakota v. Wayfair. So the issue is whether out-of-state retailers, predominantly at this point in history, online retailers, can be required to collect sales tax from purchases. So basically, old Supreme Court precedent says if you don't have a physical presence in the state, you as a vendor don't have to collect sales tax. What this means as a practical level is that state and local governments are losing billions of dollars a year. Because while individual taxpayers like you and I, when we buy on Amazon or Wayfair, we owe that tax, we don't pay it because we're expecting Amazon or Wayfair to collect it, but they're not. So the Supreme Court may say, hopefully will say, that even if you don't have a physical presence in the state, if you are selling in a state, you have to collect.
What's the timeline of this case? Because the precedent for the state or for the national involvement is the Quill decision,
right?
And that dates back to 1992.
It does.
So here we are in 2018. So what has happened since 1992, and then what's the timeline here in 2018 for resolution one way or the other potentially?
So the drumbeat since 1992 is that the world changed. Jeff Bezos was not selling books out of his basement in 1992, not quite yet. It was a couple years later until he started doing that. The long and the short of it is the first reference to the internet made on television was about 1994. So what has changed is that, yeah, there were mail order catalogs in the United States. There were salespeople on the street selling things before, but the reality is at this point in time in our history, we have purchasers buying more and more online. So physical presence at one time maybe made sense. That really showed that you had a connection as a vendor to a state if you had a physical presence in the state. Now you don't need a physical presence at all, and you can do millions of dollars worth of sales. So what has really changed since 1992 is the economy and the marketplace and how people are buying goods and how sellers are selling them. In terms of the time frame for the case to be decided, so we're kind of lucky because the Supreme Court heard this case in oral argument in April, and its term ends, practically speaking, at the end of June. So the court has to issue a decision by the end of June. It can be the case that the court can hear oral argument in a case in October, and we have no decision until June, which is a real nail biter. Here we just have a few months. Oral argument in April, a decision in June. I predict it will be the week of June 18th where the Supreme Court will issue a decision. Now, will it make mainstream media? It's so hard to say
right.
Because there are so many big cases this term. We've got partisan gerrymandering. We've got a union dues case. We've got a case involving two men who wanted to get married to buy a wedding cake. All these cases and more, the travel ban, all these cases and more will make the mainstream news. But regardless of whether this makes the big news or not, this is big news for local governments. This is bigger news for state governments because the revenue being owed is yours. It belongs to no one but you. So, if you follow the league's website, their social media, you will be the first to know, I am sure.
Yeah, absolutely. Well, the Utah League of Cities and Towns is a proud member of the SLLC, and we appreciate your advocacy on behalf not just of our cities and towns here, but on behalf of our brick and mortar businesses that line main streets across the state of Utah and local governments really across the country. Can you give us just a quick insight of how the SLLC has helped propel this case to be heard right now?
Absolutely. We filed an amicus brief a couple years ago in a case where we asked the court to reconsider this old precedent from 1992 and 1967 in a case that was essentially on another topic. And Justice Kennedy, the swing justice, the justice that tends to vote in the middle, wrote a concurring opinion saying, I was on the court in 1992 in the Quill decision. I voted against the state, but I think we should reconsider this. So he sort of famously asked the legal system to bring the Supreme Court a case to rehear its decision in Quill. And so the Justice Kennedy opinion was based on the State and Local Legal Center's amicus brief because no one else was asking the court to overturn Quill in a case sort of unrelated to Quill from 1992. And Justice Kennedy cited to a bunch of the statistics that we had in our brief about why this 1992 decision was so bad. So I can't say that he cited to our brief because he didn't, but he certainly did rely on it. So it was that brief that got the court thinking about this and prompted South Dakota to pass a law to be tested by the United States Supreme Court. So the State and Local Legal Center, with the support of the National League of Cities and the Utah League, was able to get this case effectively before the Supreme Court.
Well, thank you for your advocacy, and thank you for being the trigger to bring this case forward. Because you're right, the world has changed substantially since 1992, and one way or the other, right now in 2018, we're going to have an answer of what the collection and remittance of online sales tax is going to be for local and state governments around the country. So thank you very much for your advocacy, and we're proud members of the organization. And we could chat about a whole variety of other cases, but we'll save those for future discussions. So thank you for joining us for our web chat. Thank you for joining us at our conference. And if you have any additional questions for Lisa or for us at the League, you can reach out to us on our website. You can reach out to us via email or social media. What's the best way to find out more information about the SLLC? What's your website?
So we do have a website, which is statelocallc.org. And if you just Google State and Local Legal Center, you'll have no problem finding us.
Terrific. Terrific. Well, thanks again, Lisa. And remember, this is Cameron Diehl signing off that government closest to the people governs best.